Suing a company involves more than simply filing papers. You must first assess whether the company is still registered, has assets, and whether you are financially in a position to commence legal action. These early checks set the stage for any court or statutory demand strategy. First, check with the Australian Securities Investments Commission, or ASIC, to ensure the company is still registered. If it has been deregistered, you may need a court order to reinstate it before proceedings. Next, assess whether the company actually has money or assets, vehicles, trade tools, property or cash. Without recoverable assets, the value of suing diminishes. Also ask, do you have a personal guarantee from directors or security over company or personal assets? These improve your recovery prospects. Finally, do you have the funds to begin legal action? Remembering costs may be high, and even if successful, you may not recover them all. If the debt is undisputed and at least $4,000, you may issue a creditor's statutory demand under Section 459E of the Corporations Act. You must use the correct form, which is Form 509H, and an affidavit in support, Form 7. Defects in the form can allow the company to have the demand set aside and seek costs. If the company does not comply within 21 days, either pay, settle, or challenge the demand, it is deemed insolvent and you can apply for a winding up order. If the statutory demand is not appropriate, you can commence proceedings in court. Choose the correct jurisdiction. For example, the Magistrates Court for debts up to $150,000, District Court from $150,000 to $750,000, or Supreme Court for debts above $750,000. You begin by filing a claim and statement of claim under the UCPR. Service on the company must comply with the Corporations Act requirements at 109X, for example, posting it to the registered office or personal service on a director. If the company files a defence, you will exchange disclosure, attend settlement conferences, and then perhaps proceed to trial. If the company fails to defend, you may obtain default judgment, then enforce that judgment. So in summary, start with the right pre-action checks, then decide between a statutory demand or a court claim. Ensure you follow correct forms and service rules, and be ready to enforce any judgment. This process involves risk and cost, so professional legal advice is critical. Reach out to our experienced team for a free 30-minute consultation with our commercial litigation professionals, and let us help protect your rights.